Hi, and welcome to Financial Solutions. I'm your host, Mark Rigney. A foreclosure in real estate is a difficult transaction. There are many ways to lose a home, but signing away ownership in a manner that ruins credit, lowers property values, and strips a family of dignity is one of the hardest. For owners who can no longer afford to keep mortgage payments current, there are alternatives to bankruptcy or foreclosure proceedings. One of those options is called a short sale. If you want to execute a short sale, you want to pay close attention to today's show. What you can learn from our expert can help in a multitude of ways. Today, we will discuss this process with a real estate attorney who specializes in mortgage modifications and short sale transactions, Karen Kennedy from Karen Kennedy Associates. Hi, Karen. Thanks for being here today. We're excited to have you.
Thank you for having me.
Karen, why don't we start by sharing with our viewers a little bit about your professional background?
Well, I've been a lawyer in Virginia for 32 years. I started out in Loudoun County, and I actually, for about 15 years, owned my own title company and ran it. And I've always done real estate transactions and other litigation areas of the law.
How long have you had your private practice for now?
32 years.
32 years, that's amazing. Well, that's fantastic. Why don't we start by telling us who actually qualifies for a short sale?
Well, you have to be a borrower with a hardship. Now, there's many different types of hardship. One is if there's been a death in the family. You've lost somebody's income because of a death.
Divorce?
Divorce also, same thing. There's a lessening of your income.
Loss of a job?
Loss of a job or loss of hours in your job. Any income reduction qualifies you to do either a modification or a short sale.
Is a short sale a last resort, or there are some things that maybe our viewers should do before attempting to do a short sale?
In my practice, what we usually recommend to a borrower who would like to stay in their home, that they try to seek a modification first. A lot of the same criteria as a short sale, and it may let them stay in the home, get an affordable payment. And a lot of borrowers like that. But if they don't qualify for a modification or they are facing an immediate foreclosure, then short sale may be an option.
Okay. During the short sale transaction, you hear the terminology BPO. Why don't you share with our viewers what a BPO is exactly?
A BPO is a broker price opinion. And what that is a real estate broker, licensed in whatever state you are in, will compare sales in the neighborhood where your property is located. And they will come up with 3 or 4 recent sales transactions. And that will show the lender what houses similar to the client's is selling for.
Does the lender have an opportunity to disagree with the BPO? Can they reject it?
A lender can reject a BPO. They can get their own BPO. They can ask you to get an appraisal. But generally speaking, if the broker is qualified and has done the opinion, they will accept it as true.
Okay, okay. You mentioned hardship statement. What exactly, why would one need a hardship statement who is maybe already delinquent?
Well, what they want to make sure of is that you're not a borrower who has intentionally gone into default or who just does not want to continue to make their mortgage payments. They want to see that there's been some life event which is making this very difficult for you to stay on in this home.
Okay, now a short sale is when they sell the home for less than the balance that's owed on the home, right?
That is correct,
okay.
Yes.
What is the difference between the sales price and the loan balance? What happens there?
Well, that's called a deficiency. And a deficiency is a number that the borrower may have to negotiate with the lender. The lenders obviously want to get as much money as they can when there's either a foreclosure or a sale. And so they are going to start out in the position that the borrower owes them that difference. The other problem is a lot of borrowers who refinanced between 2003 and 2007 got a second on their home.
Okay.
And the second sometimes can be with the same lender and sometimes it's with a different lender. And that has to be taken into consideration. 9 times out of 10 in today's market, the second loan would be wiped out in a short sale. But sometimes the second lender says, I'm not going to release my lien unless you pay me some money. So it's all a matter of negotiation with the lenders.
Okay, so let's say you execute a short sale and there's a deficiency. Say you do a $300,000 value of the home, but $250,000, you get $250,000 for it. Can the lender or servicer come after the seller for that extra $50,000?
If there hasn't been an agreement prior to the closing and the transfer of title between the lender and the seller, yes, they can treat the deficiency just like a huge credit card debt and come after the borrower at that point.
Okay, is there a name of a specific document that agreement is called that should be signed if they want to protect themselves from the future, the lender coming after them in the future?
It's called a short sale agreement.
It's just that simple, a short sale agreement. You need to make sure you have the short sale agreement signed prior to going through with the short sale to make sure that you're protected.
Yes, you need to have it signed with the primary lender. If you have a second lien on the home, you need to negotiate with them about what it will take for them to release the lien and release the deficiency against you.
Now that's with the lender. What about the IRS? Can they consider that forgiven debt, that $50,000, can they consider that forgiven debt as income?
Yes, under the current tax code, any forgiveness of debt is considered ordinary income to the borrower. But due to this financial crisis, Congress passed a Homeowners Protection Act.
Okay.
And until December 31st, 2012, they have directed the IRS not to seek to collect that income.
So if you're going to do a short sale, it's highly recommended that you do it before the end of 2012.
I would say so, because who knows what Congress is going to do.
Will the fact that a seller may have other assets, will that dictate whether the servicer or lender will approve the short sale?
Yeah, that's a very good question, Mark, and it's something that sellers need to be very aware of. There's certain types of assets that the lender cannot go after.
Such as?
Such as your IRA, your 401k.
Retirement assets, basically.
Retirement assets, basically. But if you have a second home somewhere, if it's paid off, if you have other assets.
Liquid assets, money in the bank account.
Yes, they are going to want to know about that, and if they see that you have these assets that they could get some cash out of, they're going to be reluctant to forgive 100% of the deficiency.
Are you required by law to disclose those assets to the servicer during the short sale transaction?
I don't know if it's by law, but the servicer and the lender are going to make you fill out essentially the same documents that you do for a modification. Here's my income, here's my list of debts, here's my list of assets. And you have to swear to that document under penalty of perjury.
Well, who actually sets the price on a home during a short sale transaction?
The real estate agent / broker should counsel with their client.
Okay.
And the two of those entities should set the short sale price. However, it's always good to involve the lender early and often. Let the lender know that you're in the short sale process. One of the great things about it, it will, in many cases, avoid a foreclosure action against you. And they should be involved from the beginning, because if they're going to say, no, that price is, we're not going to accept it under any circumstances, then you can find that out earlier.
That brings up a good point. Should, during the negotiation process, a seller contact, or the real estate agent contact the servicer to see if they would approve that, or do they need to go ahead and sign the contract first, then send it to the servicer?
I think it's always wiser to contact the lender right at the time that you sign the listing agreement.
So the lender's going to have input on the amount of contract that they will accept.
Yes.
They can actually reject the contract if they don't feel as though it's applicable, if they don't feel it's worth the value?
Totally. They will reject it. And they also get very irritable if you don't communicate with them about when you are originally listing the property.
Now, when you say communicate, you mean the real estate agent should be doing that, correct?
Yes. Most of these servicers have their own program. I know Bank of America has what they call the Equator system, and some of the other servicers use it. And it's a computer program. You register to become an Equator user, and you have a username and a passcode, and then you can upload all the data dealing with your listing agreement and the potential short sale.
So would you say that the real estate agent has a dual responsibility to not only act as a real estate agent, but as a negotiator as well?
Yes, I think if the real estate agent takes the role on to get a sale approved and make a deficiency in the sale, they have a responsibility to deal with the lender. Or some of my clients have hired me to be the negotiator, mainly because of my experience with doing loan modifications and knowing generally what lenders will and will not do and what they want to see.
Is it the servicer or the lender that you need to negotiate with?
Well, that's a funny question, Mark, because generally you can't ever communicate directly with the lender. The lender is usually some trustee of a securitized pool of loans. So they rely on their servicers to do the negotiations.
So is the servicer the one who has the ability for the final approval of the contract?
Yes, sir.
Okay, okay. Why the servicer and not the lender?
Because the lender operates as a securitized trust, and basically there's a group of investors, and there's a lot, mostly institutional investors. There's an investor committee that meets and decides what their criteria will be for a loan modification and for a short sale or for a deed in lieu of foreclosure. Any of those alternatives that result in them getting less than 100 cents on a dollar, the investor committee directs their trustee to direct the servicers, this is what we will agree to do. This is our range of options that we're comfortable with.
Okay. Okay. Now, say our viewer has received a foreclosure notice. They're getting those letters in the mail. Can they at that point apply for a short sale, and will that short sale stop the foreclosure proceeding?
That's a good question. It really depends on how close you are to the foreclosure sale. I think you cannot list your property the day before the foreclosure sale and expect it to be stopped. You need to get to somebody very quickly. If you get a foreclosure notice that has an actual date, September 24, 2011 is your foreclosure date, you need to be speaking to an attorney or a real estate broker that day.
They need to become proactive. Don't just wait for things to happen. Go after it and try to solve it as soon as you can.
Absolutely, because I have so many people that come to me and they'll say, we got foreclosed on last week, what can you do?
It's too late.
And my range of options has shrunk at that point. There's some things I can do, and there's some ways that I might be able to reverse the foreclosure, but instead of having these options, you have these options.
Would the lender rather have a foreclosure as opposed to a short sale or vice versa? Because the foreclosures are sold on the courthouse steps usually.
Yes.
So would they rather have a short